morning.
Good morning, Council.
May it please the Court, George Vaca on behalf of the appellant, Cathedral of Faith Church, along with Nancy Lawton of my office. If I can, Judge Castanueva, I'd like to reserve 5 minutes, please, for rebuttal.
Thank you, sir.
We're here this morning asking the Court to reverse a final judgment regarding an assessment of attorney's fees, costs, and prejudgment interest entered in favor of the Church's CGL insurer, Old Dominion, and asked that the Court remand this case for a new evidentiary hearing concerning the issue of attorney's fees, costs, and prejudgment interest.
Let's go through, if I can, Mr. Vaca. Let me just kind of cut to the chase.
Yes,
As
yes,
I understand, we have at least a procedural history of this case, that this matter was heard as to the issue of entitlement in front of Judge Nielsen.
Correct.
Judge Nielsen granted what is a summary judgment on the basis that there's really no other issues remaining. Summary judgment is granted, and I find entitlement to your client for fees, reserved jurisdiction to have it heard at a later time. And for whatever reason, I don't know whether Judge Nielsen was transferred to another division, you have a totally different judge handling the actual hearing for the determination of those fees, correct?
Yes.
All right. And walk me through what transpired at that hearing on that determination of the fees. At the very outset, and looking as to what has been, I'll tell you what seems to me, and perhaps maybe your counsel on the other side would be alerted to that, because I'm troubled by that. As I read through what transpired at this hearing that's supposed to have been on the determination of the fees itself, that in essence it was a redo all over again as to the issue of entitlement. Help me out with that.
Well, Your Honor, that's probably the meat of the coconut when it comes to the complaint that we've raised and the issue that we've raised on appeal. At no point in time did Old Dominion file a motion for rehearing in which they requested the Court to reconsider the entitlement issue. At no point in time was there a notice of hearing in which our clients were advised that this would be reconsidered. What happened was they appeared before a new judge and they packaged the entitlement issue and they wrapped it up with a bow with respect to amount. And what they said was, well, Judge, you need to go through this quanstrom analysis, this row analysis about how many hours and the hourly rate and how much they should pay. And the answer should be whatever the hourly rate was. I believe Ms. Klein testified to $250 an hour. And that she thought that 31 hours was devoted to the case of however many hours were submitted by Mr. Haynes, but that the amount per hour, or the amount that should actually be awarded, is zero because the litigation was unnecessary. And Judge Ulmer agreed with that and wrote a very extensive order in which, a final judgment, in which two sections of it seemed to me to be devoted to the entire entitlement issue, which had previously been determined adversely to the insurer by Judge Nielsen. One of the specific findings in the final judgment is there was no need for the plaintiff to file the subject lawsuit to obtain the appraisal award. And the citation for that ruling is to Ms. Klein's testimony before Judge Ulmer. So
this was based, I suppose my question to you, is this like a lack of due process? Your clients were not aware that they were going to rehash this at that time?
We've certainly said that there was no notice, there was no motion. So typically, the cases that we've cited said that you need to at least be apprised that this is going to be an issue. And I don't want to say, Your Honor, I want to make sure I don't misspeak, because Mr. Hayes, at the commencement of this hearing, said, hey, something to the effect of, and forgive me, I should have had the exact page site ready for you, but said something to the effect of, hey, we're not going to re-argue this, are we? Because if we were, I would do something maybe differently.
And didn't they, at least, and correct me if I'm wrong, didn't they say, well, no, we're not going to re-argue entitlement here?
Correct.
and then it went forward.
Whatever you do, don't think about the purple elephant in the room, because we're not thinking about purple elephants, and that's precisely what they went ahead and did and argued and got Judge Ulmer to rule. That was precisely what Ms. Klein testified to in her role as the expert witness in this case. It was the argument that was asserted. Throughout the course of the proceedings, it was, don't worry about this, Judge, because we're just preserving this for appeal, but if you want to think about it now and fix this problem now, fix it now, which is precisely what Judge Ulmer did.
Was this hearing conducted over just one day, or was there multiple hearings?
It was, well, this particular one in front of Judge Ulmer was a 2-day evidentiary hearing. There was also a hearing in front of Judge Nielsen back in October of 2010, which then formed the basis of his March 2011 order granting the entitlement.
At some point through this 2-day hearing, I guess you weren't trial counsel, but I mean, I would assume it must have dawned on the attorneys for the church at some point that, hey, we're now faced with a different animal here.
Well, at which point the attorney for the church did try to point that out to Judge Ulmer, in which case he was met with the objection that he had not requested that Judge Ulmer take judicial notice of the March 2011 order which determined entitlement. And Judge Ulmer then sustained the objection, in effect ruling that Judge Ulmer could not consider orders in the very case in which he was sitting absent a request for judicial notice.
That does seem like a unique argument.
Well, if you take that to its logical extreme, having just come off of a 2.5-week tobacco trial in Orlando in which there were probably a couple of hundred pretrial rulings, I can't fathom how you would make that work during the course of a trial if you're asking a court to judge rule in accordance with the order in limine, and then, oh, by the way, you need to do a request for judicial notice of that order every time you assert that objection. It would be crazy. It simply isn't workable. But the lawyer did sense that something was coming down the road. He did object. He did ask the court to look and to follow the March 2011 order. He was met with the objection, and it was sustained.
Given that that's the case, I mean, I'm not sure how that, and maybe that's not your argument, I'm not sure how it amounts to a denial of due process.
Well, I think you're being asked to revisit an order, and there's an issue that's being presented that for which there was not proper notice. So you can sit there and you can complain about it, which is what he did. Certainly, I would think if, for instance, and I'm trying to think of a situation that might come to mind, if some judge would say that he was holding me in criminal contempt, I might object to it, and the judge could find me in criminal contempt without an evidentiary hearing, and I still might have a due process argument to assert to overturn that ruling, is where I'm kind of thinking that might be something analogous. But in this case, it was clear that there was an order that had been entered granting entitlement, and Judge Ulmer quite clearly, at least in my view, signed off on a final judgment that said there was no entitlement.
I mean, there's no reason that a judge can't change a interlocutory ruling before the final judgment is entered.
Well, a successor judge generally doesn't have the authority to do that unless there's been, and we've cited the cases in our briefs that talk about this, but generally unless there's been a change in the facts, and in this case there were no changes in the facts, or unless there's been a change in the law, which there was not in this case, or some unique change in circumstance, or some procedural aspect, none of which happened here. Generally, it's been found, and we cited the court to a third DCA case, a Gemini case. The courts have found that it's an abuse of discretion for a successor judge to go ahead and to revisit an order.
But wouldn't you concede at least that there certainly was a fuller and more detailed and comprehensive exploration of the facts about entitlement than occurred when Judge Nielsen ruled initially?
There was a 2-day hearing where there wasn't a 2-day hearing the first time, but if there was a complaint about the evidentiary hearing or any type of lack thereof or deficiencies in that hearing, that should have been addressed to Judge Nielsen, in my judgment. You can't sit there and wait till he rotates out of division and then without notice to anybody that you're seeking a rehearing as to the underlying basis for the hearing for which you are appearing, which is amount, to then sit there and say, oh, by the way, you shouldn't get anything at all, without even saying we were denied an opportunity to be heard in front of Judge Nielsen. There was nothing.
Because I'm trying to understand, Mr. Vaca, because one of the things you said about successor judge, a successor judge could revisit matters in a case. Let me just kind of push that out of the way. But in this case, what troubles me, and I want to make sure that if that is your argument, that you were not placed on notice at this hearing that they were going to re-argue the entitlement matter. And I agree with Judge Ross. I mean, it's written beautifully and very detailed, making reference to testimony as to why the entitlement. But whether that's right or wrong, as I see it, it's a non-issue. Were you placed on notice? But Judge Wallace raises an interesting point. Is there almost like the fact that it did develop over 2 days, is that enough? Was the objection preserved for us to consider?
Well, Your Honor, I don't know what more that the lawyer could have done. He objected. He provided the court with the order. The defense, the insurance company, objected to the judge considering the order or having it be put into evidence, and that objection was sustained. I don't know what else he could have done at that point in time. He was attempting, remember, all of this came up, I believe, after he had already rested his part of the case with his expert witness, and it was happening when Ms. Klein was on the stand. Mm-hmm. And the church's attorney was attempting to cross-examine her with Judge Nielsen's order, asking her if she had known that Judge Nielsen had found that Old Dominion had breached the contract, at which point there was an objection. He attempted to impeach her with that order, and it was kept out of evidence.
But I mean, it's clear, though, that at some point, Judge Ulmer was aware of the prior order from Judge Nielsen.
Well, he was aware of it, but he didn't specifically say he was setting it aside either. All he said was, yeah, wink, wink, I'm aware of it, and I'm going to agree that none of this time was necessary, which was absolutely contradictory to the findings that were raised by Judge Nielsen. And I would point out, okay, to this day, okay, there's never been a challenge to Judge Nielsen's order. There's no cross appeal in this case. There was never any type of motions for, they've never challenged that order, not once. Instead, what they did is ostensibly at a hearing to determine two things, a reasonable hourly rate and how many hours, perhaps a multiplier.
Could it be, maybe that question is more directed to them strategically, that they didn't raise a cross appeal here on the issue of entitlement on Judge Nielsen's? Because it is, we could agree that that was a non-final, non-appealable order when Judge Nielsen made his ruling. So it would be in this appeal, if they filed a cross appeal, that issue would become ripe as to whether or not Judge Nielsen got it correct at that hearing. So is it strategic that they're not filing a cross appeal?
I'm certain that it all goes back to the basic bottom line on these types of cases is whether or not there's 627.428 fees available. And the strategic reason why they didn't do that is because they want to take the position in front of this court, as they've done in their brief and as they did below, that we're not talking about entitlement, because if we are, then there's potentially attorney's fees running on this appeal as well. What they're saying is, no, that's exactly what they said below. We're not talking about entitlement, we're talking about amount. The amount is zero. That's what they said. That's what she testified to. That's what the strategy is. That's what the strategy in all these cases are, is that we want to avoid talking about entitlement, because if we don't talk about entitlement, even though entitlement's the pig, and we put a lot of lipstick on that pig, okay, and it's still going to be a pig at the end of the day, we're saying, no, that's not what we're talking about. That's the strategy, is to avoid ongoing assessment of attorney's fees.
If we jump to the merits, It seems like the argument reduced to its essentials was that there was no way that the insurance company could have known that the amount that they had agreed to pay was objected to or in controversy, and for that reason, there was no reason to file the lawsuit, or they had no reason to understand that the church was looking for more money.
Well,
do you want to address that?
yeah, I appreciate that that's their argument. Of course, that's the argument that they want you to focus on, as opposed to looking at almost every single communication that was sent by the adjuster, Mr. Hartman, to the church, to the public adjuster, or to Mr. Haynes, the lawyer. Almost every single one of those, including the January 22nd, 2007 letter that enclosed the checks, had in every one of them had a paragraph that said, we are reserving our rights to deny coverage under the policy. Every single one of those said that. If you look at the sworn proof of loss that was attached to Mr. I believe it's Hartman's affidavit, at page 740 of the record, okay, you'll see that there's a receipt for payment in which the insured has to acknowledge that it's in full satisfaction and indemnity for all claims and demands upon said company on account of said loss and damage. So what the attorney for the church was saying was precisely true. Here's the checks, okay? The letter said you got to execute this sworn proof of loss in which you were acknowledging full satisfaction of your losses.
Mr. Locke, I didn't interrupt your answer when you were giving it because you'd hit 15. I want you to get your full answer.
Thank you.
But you have gone into the...
Okay, let me just finish this. So you have to, in order for us for you to cash those checks, you got to sign this satisfaction. And oh, by the way, the threat's there that if you don't, see the duty to cooperate. It's on the second page of the letter that he sent. If you don't, we reserve the right to deny coverage to you, which goes right back to Bassett. It goes to the Lewis case out of the fourth that the courts talked about in previous decisions. That's where we're at, in my humble opinion. I'll save whatever time I have left. I hope I've answered your question, Judge Wallace.
Good morning. I'm Hinda Klein here on behalf of Old Dominion.
Because that issue has been really concerning me. You did not file a motion for rehearing after Judge Nielsen's order. And this hearing in front of Judge Ulmer, that was, as I review what has transpired, it was a full opportunity for you to basically make a full argument as to entitlement all over again. And then on appeal here, I was surprised you did not file a cross appeal. So you're asking us, in a way, to go into the entitlement issue, and that order, even though it says, well, I find zero, in essence, it's a rehash on the entitlement. I'm troubled by that, given the fact that they were not placed on notice. They objected that this hearing was supposed to be strictly as to the amount. I'm concerned about that. I want you to address that.
And I understand the court's concern, but and there's a couple of things that I want to correct the court on. And the first is that there was no reason for us to have filed a cross appeal, and there's for two reasons. The first is because we were successful in our motion for summary judgment with Judge Nielsen finding there was no breach of contract.
Did he make that finding, or was it simply say, motion for it appears that the parties have resolved it, that's why summary judgment is entered? But did he really make a specific finding that there was no breach of contract?
What the court said is, and this is at page 1085 of the record, Old Dominion's motion for summary judgment as to the breach of contract complaint is granted.
What paragraph?
Paragraph 1. Order granting Old Dominion's motion for summary judgment as to the breach of contract complaint. There was never a finding in this case that Old Dominion breached its contract. And at no point in time did Cathedral of Faith ask the court to revisit that ruling, which was directly contrary to its subsequent ruling, finding that this lawsuit was necessary. So the court made conflicting rulings, one of which, the primary one of which, was in our favor. Absent a breach of contract, in essence, Cathedral of Faith could not have been deemed the prevailing party in this matter. So Judge Nielsen's subsequent order, which was, I think, 5 months later, in July of 2011, confirming the appraisal award, did not find that there was, in fact, a breach of contract, nor did the court find that they prevailed on any of the allegations contained in their complaint. It simply found that for some reason that I'm still unclear, that they had to file suit in order to get paid. He never found at any point in time on this record that Old Dominion had any prior notice of any disagreement, nor could he have found that. So that was the primary reason why we didn't cross appeal, because we had the breach of contract count in our favor. And the secondary reason was simply because we're not aggrieved by the trial court's order on appeal in this matter. We didn't want to pay attorney's fees. We argued we shouldn't have to pay attorney's fees, and the court ultimately ruled we didn't have to. It would be redundant and pointless for us to then have appealed an order that was essentially in our favor, regardless of the fact that Judge Ulmer didn't technically revisit his order, Judge Ulmer's prior order on Nielsen's prior order on entitlement. Frankly, I think it's probably because the judge was concerned that as a successor judge, it was not one of those things that is generally done, but there were significant facts and issues that came up in the 2-day evidentiary hearing that Judge Ulmer had not considered.
Let me take you back, because you made a comment, or you made a statement as to the court finding no breach of contract. I'm looking at Judge Nielsen's subsequent order on the motion for confirming the appraiser. In paragraph 27, he makes a specific findings that this court finds that the breach which caused the filing of the lawsuit was, and he says in details, the failure of the insurance company to properly tender what they agreed to under the policy without condition, failing to tender any amount. So there's this is the March 18th order. And in that order is when he makes the finding of entitlement. That's where I'm struggling with that. So I have this order. Here's a judge who basically makes a specific ruling as to entitlement, that there was a breach and they're entitled to fees. Then you fast forward, a separate judge altogether. If they were given notice, and I guess I'm still struggling with that, hey, we disagree with that, Judge Ulmer, you're a new judge here, as a successor judge, you could revisit, we have a real problem with Judge Nielsen, to give the other side notice that they are gonna do that, that may be the case, but I'm troubled with that.
And it was, I think, a conundrum for all of the attorneys involved. At the evidentiary hearing, initially, Judge Ulmer said, I'm not going to reconsider entitlement. There was, at that point, there's no way for us to then have moved for rehearing. I guess certainly we could have moved for rehearing on the motion to confirm to confirm the appraisal award, but then again, we had the order granting us summary judgment on the breach of contract. We have...
But how'd you reconcile that with this other order?
With the subsequent order that we are...
Yes, ma'am. Aren't they kind of in conflict with each other?
Well, one was rendered by Judge Nielsen without an evidentiary hearing, and the second was entered by Judge Ulmer after a lengthy evidentiary hearing. And
and I go back to what was the evidentiary on? It was purely, I mean, his order, here's his testimony that was provided. It was almost like a rehearing on the entitlement without notice.
Well, first of all, I would disagree with that, because I think in any attorney's fees hearing, you must consider the reasonableness and necessity of the attorney's fees. And to some extent, I guess, especially in this kind of a case, it's going to overlap with certain issues on entitlement that might have already been determined. But in this case, the evidence, according to Judge Ulmer's final judgment, was so overwhelming that there was never any reason for the Cathedral of Faith to ever file this lawsuit. And I just think that after hearing all of the evidence and testimony, the court, on its own volition, determined to essentially reconsider and do essentially reconsider the order on entitlement by finding that none of the fees involved were necessary or reasonable, because Old Dominion indisputably, and there's never been any dispute on the material facts here, indisputably was never given notice before the lawsuit was filed and served that there was any disagreement with the amount that it ultimately tendered. And I do want to address one thing that opposing counsel argued, and that was, first of all, he began his argument by characterizing Cathedral of Faith as a CGL insurer. This is a property insurance policy. There was no reservation of rights as that term is defined in the Claims Administration Statute, which only addresses third-party claims. What the letters were that were sent to Cathedral of Faith simply said is, we need certain information. We're reserving our rights to investigate and do whatever we are entitled to do under the policy. Oh, and by the way, we acknowledge, and I'm quoting from the April 7th, 2006 letter, pages 671 to 673, we acknowledge that you too have rights and obligations under the policy. And this is the specific language that they are claiming was a reservation of rights, rendering the tender conditional as opposed to unconditional. By stating the above, acknowledging the claim report, and by investigation of the reported loss and claim, Old Dominion does not waive the right to rely on any provision, terms, and conditions of the policy. It expressly reserves all rights it has under the policy and applicable law, including, but not limited to, those that exclude or limit coverage, permit investigation, and request documents, or limit the extent of its duty to indemnify. Just as all our rights are reserved, so too are all rights of the insured under the policy. There was never any breach of contract on the undisputed facts of this case, nor was there any wrongdoing on the part of Old Dominion. In fact, the evidence is legion in this case that they did every possible thing right, and that's what Judge Ulmer got.
And if I may, and you may be, that may be all be correct, and I'm not here to say what Judge Ulmer's final judgment was correct, but I am more concerned is it proper at this time for us to be looking at all of that, given the fact where, and I guess the question becomes, okay, what can a successor judge do? You're telling me that the judge on his own decided to do that? That he basically decided to rehear the whole entitlement issue, as opposed to taking it as a face value. Okay, there's a determination by the predecessor judge that there is that there's a failure, there's a breach, then right now just computate the amount. So a successor judge can reconsider, but typically, I guess the notice issue to the other side so people would know. And I'm still concerned about that, because here we probably have an appropriate order, a correct order under the law, but without giving the party notice and opportunity that, hey, I'm going to redo all of this. Be prepared, so we could re-argue the whole entitlement as to whether or not the suit ought to have been filed or not filed. That's where I'm concerned.
Well, I don't believe that Judge Ulmer set out to reconsider the court's order, and in fact, he explicitly refused to do that.
But how can you say that if you look at the final judgment, every single I mean, it reads like very, very specific and making reference to testimony, it's all about the underlying claim.
That's correct, and on rehearing, the judge said, listen, I have considered every shred of evidence, all of the pleadings, all of the motions, the entire court file, and these are my findings. I believe that the court did not set out to reconsider, but I believe...
This is not a rehearing. This was on a motion for the cost, correct, for just to... Okay,
correct, but there was a rehearing motion that was filed in response to that order.
Okay.
At which time they, of course, raised the due process concerns that they have, as well as other concerns, and certainly raised Judge Nielsen's prior order and said, you know, you can't do this as a matter of due process. First of all, I don't think it's a matter of due process. Neither one of these parties was given the opportunity to re-argue the merits. It simply was a presentation of the evidence as to the reasonable and necessary attorney's fees. I cannot guess what was in Judge Ulmer's mind at the time that he made his decision on it, but certainly I didn't see anything, and I did do the research, that says that a court cannot unilaterally itself, without a motion, decide to change its mind. The court can do that. The successor court can do that. I think that Judge Ulmer, in the course of this very lengthy evidentiary hearing, an evidentiary hearing that Judge Nielsen did not have the benefit of, said to himself, I can't see any good reason to award Cathedral of Faith. I think it was over $350,000, when at no point in time did they ever have to file this lawsuit. And that was the upshot of his 19-page, very well documented final judgment. And as a reviewing court, it's this court's obligation to look at the bigger picture and to determine whether or not this order, whether technically or untechnically correct, was in error, and it wasn't. There was no error because the judge was, I don't know whether you want to characterize it as right for the wrong reason, but the judge was absolutely correct. And reversing it on a due process violation when they certainly had every opportunity to litigate entitlement on several occasions and have yet to say in their briefs or an oral argument what it is that they would have done differently, what evidence they didn't introduce as a result of the failure of Judge Ulmer to say, I'm reconsidering entitlement. In the absence of any such argument or any contrary evidence to the findings of Judge Ulmer, we submit that the trial court was absolutely correct, that any error, if there was in fact any, was harmless, and that this court should affirm the $0 in attorney's fees, costs, prejudgment interest that was awarded by Judge Ulmer. Thank you.
Thank you.
May it please the court. You know,
Just
there's...
so you know.
Thank you. There's a couple things. In these letters that were sent by Old Dominion, Ms. Klein says there was no reservation of rights. Well, I would beg to differ with her. In each one of these letters, starting with, in, I believe, May of 2006, there was reference to you must sign the sworn proof of loss, which I've already cited to the court, requires them to release and limit the amount of their coverage. But if you look at the letter of January 22nd, 2007, which is at page 747 of the record, and you read this, okay, it includes the 3 checks for buildings 1, 2, and 3. And then Mr. Hartman says, I have also enclosed a sworn proof of loss form. In exchange for the above drafts, please have our insured complete, have signature notarized, and return in its entirety per the terms and conditions of the policy. Those terms and conditions are included below. Please send completed form to. And then he cites Section E, loss conditions of the policy, which says you must see that the following are done in the event of loss or damage to covered property, and there's a list of 8 obligations that he cites to. And then the immediate next paragraph is, Old Dominion Insurance Company is investigating this loss under a reservation of rights. In no way is this investigation meant to prejudice your rights or Old Dominion Insurance Company's rights under the policy or any of its conditions. Old Dominion Insurance Company reserves the right under the policy to deny coverage to you or anyone claiming coverage under the policy. That's the letter that's sent with the checks that they're saying we're supposed to object to. Now, step back. Let's go back 14 years to Bassett versus Standard, okay? In that case, Ms. Bassett is making a claim for uninsured motorist benefits. Standard says, we want you to execute this particular type of medical records release. She objects to it. Standard repeatedly says, we're not denying coverage, but if you don't sign what we want, we might deny coverage to you. And this court found a couple of things in that case. It said, because the insurer Standard Fire engendered a dispute concerning Mrs. Bassett's uninsured motorist benefits in which it threatened a denial of coverage, we hold that Mrs. Bassett, the insured, is entitled to recover attorney's fees. What did they do in this case? Okay, every single time they communicated with the church, they said, there are these conditions, X, Y, Z. And if you don't comply with these conditions, we're not denying coverage, but we're reserving our right to deny coverage to you for failure to honor these conditions. They engendered the very dispute they're now complaining about. This has happened over and over and over again.
In the letters or on the checks that these checks were tendered in full and final settlement of the claim?
There is, with respect to the second page of the sworn proof of loss, which they were requiring that the client sign, in which in the receipt of payment part of it says it's in full satisfaction and indemnity for all claims and demands upon said company on account of said loss and damage on the bottom page of the proof of loss. So it's not on the check, it is on the sworn proof of loss. The court found in its order, and thank you for finding that, I'm sure Ms. Klein didn't mean to misstate the order with respect to the finding regarding the breach, Judge Guzan. But that order says a couple things. It says the court finds that the breach which caused the filing of the lawsuit was the failure of the insurance company to properly tender what Old Dominion agreed it owed under the policy without condition. That's the January 22, 2007 letter with the list of conditions, the threat of the coverage, and the requirement that you execute the sworn proof of loss. And the court finds further at paragraph 28 of that order that the court further finds that retention of counsel in the filing of the lawsuit was necessary to obtain the initial payment unconditionally, and it was only after the prior court abated the lawsuit in favor of appraisal was the true cost of stabilization determined. So,
I must advise you that we've gone beyond 4.
We would ask the court, for all the other reasons stated in our briefs, to reverse this and remand it for an evidentiary hearing consistent with due process and with the order that was unappealed from, which determined an entitlement to the fees and costs. Thank you.